Introduce myself. My name is Judge Mandela, and joining me on the panel today are Judge Brown and Judge White. Counsel, whenever you're ready, please begin.
Thank you, and may it please the court. My name is Matthew Lito, and I represent the appellant Arlington Financial Consultants, LLC. The issue before the court today is whether the trial court erred when dismissing a claim for fraud in the inducement against Stephen Galvin, an individual, based upon the independent tort doctrine and the existence of a general merger clause within a contract between Arlington and Mr. Galvin's company, USCI. Our review of the case law indicates that the court did err in dismissing the claim with prejudice because Arlington didn't. I'm sorry. I don't know if I heard something.
No, counsel, continue.
Okay. Arlington did state a cause of action. Now, by way of background, the amended complaint expressly alleges the existence of a misrepresentation of present fact that was made to Arlington to induce them to enter into a contract with USCI by Mr. Galvin. And on the record of page 336, the allegations in the second amended complaint are in paragraphs 33 through 35, and is expressly alleged that Mr. Galvin repeatedly and expressly represented that USCI had contracts in place with various lenders that allowed USCI to access to funds in excess of $350 million for use in Arlington's platform, and which would fund the home improvement projects that Arlington's platform allowed. And then we also allege that Galvin further stated that the funds were readily available for disbursement and that he had, quote, received approval from their lending and secondary market partners for the credit underwriting process. And as a result of these statements by Mr. Galvin, Arlington then entered into the contract with USCI. So with respect to the independent tort doctrine, which was the first basis for dismissal of the fraud and the inducement claim, I think the case that really is the centerpiece of our argument, I believe is the most analogous to the claims that we have, is the Costa Investors versus Liberty Grand case, which is a fourth DCA case out of 2022. And the first issue that the Costa case states is that the principle of the independent tort doctrine only applies, quote, only applies to the parties to the contract. Now, Mr. Galvin is not an independent party to the contract. He merely signed on behalf of the company. So on that basis alone, the independent tort doctrine should not apply. But also,
are you aware of Vesta Construction Design versus Lotschwitz? It's a 50 CA case about the economic loss rule and the same principles being discussed.
I am aware. I recall the Vesta construction case, not from work on this particular matter, but just in the past. Yes, I do know the Vesta matter.
So in Vesta, Judge Lawson talks about the economic loss rule, which, similar to the independent tort doctrine, is a boundary doctrine to keep contract from being swallowed at the sea of tort. And when it's being applied to an employee there who is not a professional, he finds that even though the argument's being made that the employee was not a party to the contract, that you cannot circumvent then the economic loss rule, here the independent tort doctrine, by suing the employee for performance. I understand here your argument would be that you're not suing for performance of the contract. What you're actually suing for is fraud inducing the contract, all of which predated the contract. But if we were, and I know your argument doesn't stand alone on this basis, but if we, I guess the better question is Vesta wrong in their analysis? Is Costa correct that all that matters is we look to see who a party to the contract is, and if the party is not being sued, it's not a party to the contract, they're just performing on behalf of a party to the contract, that these doctrines don't stand in the way?
Well, from what I recall of Vesta, and again, it's been a little while since I've read the case, I do believe that predated Tiara, which got rid of the economic loss doctrine. But with that being said, I don't think the analysis just rises and falls only on the fact that he's not a signatory to the contract. That's not my reading of Costa either, because Costa does go a little further as well. And Costa then says that really what the court should do is analyze the complaint to determine whether the evidence was sufficient to show that fraud occurred and whether the individual could be liable when he actively participated in the fraud. And it goes back to the statement of, it's a false statement of fact. It must be of a past or existing fact, not a promise to do something in the future.
So here, the argument would go that it's separate anyway, so it doesn't really matter.
Right. This is exactly right. I mean, whether he's a signatory or not, I actually believe that we could sue the company for fraud, although they're in bankruptcy. But because this is a statement of an actual present fact at the time he made the statement before the contract was entered into, that's why it's not a simple fraud in the performance type of issue, which would, I think, be barred by the independent tort doctrine. And that, I think, is also one of the distinguishing features in Peebles and Island Travel, which are cited by the appellee. I'm sorry, yeah, by the appellee, because in those cases you have fraud in Peebles that induced somebody to continue performing a contract already was already in place, and in Island Travel was also basically it was a breach of what the term was of a future conduct of the parties and how they were going to split certain distributions. Here, the contract just says, okay, we're going to provide this financing to you. But the inducing factor that led to the execution of the document or of the contract was we can do it now. And it's not only that we can do it now and we have these lenders in place, but it's that we already have, quote, approval from their lending team and secondary partners to go ahead and fund these $350 million worth of loans. And as we know from the other attachment to the to the amended complaint, that wasn't true, admittedly, at the time that it was made. And these are all, again, pre-contractual statements that induced action on behalf of USCI. And, I think one of the interesting points about Costa, which in Costa, there actually was the representation in the contract itself that formed the basis for the fraud claim. So in Costa, they actually signed the agreement and a borrower certificate saying that this property was owned by the entity that was borrowing the money that was going to be the collateral for this loan. That was the false statement that formed the basis of the fraud claim that was permitted to proceed based upon the evidence. I mean, the actual fraudulent statement made by the non-party to the agreement was in the document, which was also formed a breach of contract claim against that entity. And I noted that in the appellee's response, they say that, well, Costa, there was no breach of contract claim that was raised. But I mean, in the opinion itself, it indicates that there was a subject breach of contract claim against Liberty. So both of those claims were permitted to proceed together, given the facts that were at issue in that case. The same issue or the same type of result came up in the Pruitt case and also in the UKEN case. And I think, again, the issue that we're really focusing on is, okay, was there a present fact that was alleged that can form the basis of fraud? And if a corporate officer who is not a signatory to a document participates in that fraudulent conduct, that individual can be held liable. So that is what COSTA stands for. That is also in Pruitt. The distinguishing factor in Pruitt was this person said, I have enough money to operate this racing team now. And they make the analogy in Pruitt where they were the distinguish between fraud in the performance and fraud in the inducement, where somebody says, I have $10 in my pocket right now to pay for lunch. That's a present fact, where it would be fraud in the performance if they say, well, I'll buy you lunch in the future. So here we're dealing with all present facts that were expressly represented by Mr. Galvin, which permit a fraud in the inducement claim to proceed. And that's what we've alleged. Another issue that's raised in the order, really, it goes to the merger clause that's part of the contract. So what the trial court found was that the existence of this general merger clause also eviscerated a possibility of having a fraud in the inducement claim. But first of all, the appellee doesn't really address the cases that we raise in our brief as to why the merger clause is inapplicable. I mean, this goes back to the Mejia case where a typical merger clause does not stop or prevent a fraud in the inducement claim from going forward. The only types of contractual provisions that would do so would be a specific provision that says we are not going to sue you for fraud for representation. So a non-reliance clause, which we do not have present in this contract anywhere. And again, the appellee didn't really address the merger cases that we raised in our brief, which in our view, that means they waived their argument on that. Or maybe they recognize that, Mejia really is the controlling case and the merger clause is really of no moment when it comes to a fraud in the inducement matter. So when it comes down to it, the main cases that are cited in opposition to our brief really deal with issues of either, again, future performance, which certainly could be barred by the independent tort doctrine, or cases where there's, for example, in the Sun Life case, where they found that, first of all, these were two parties to the contract, but the court in Sun Life found, well, this is they're literally alleging a fraud, which is the contractual provision to check on this non-contestability items on these life insurance policies. That was specifically in the contract. And because it was specifically in the contract between the parties, there was no fraud that was found. In addition, in the Inspiration case, the court, although they found it was a close call, found that there was no fraud in the inducement that could be alleged because the misrepresentation, aside from some puffery in the difference, was exactly what the party contracted for, where they said, we're going to give you this billing software and we're going to do X, Y, and Z. That was the alleged misrepresentation, which exactly was the contract that they signed. We don't have that situation in this case, making all of those cases distinguishable. So at the end of the day, what it comes down to is we've alleged a present fact that was misrepresented to USCI, which induced them to enter into the contract. And that is really the general rule that must be looked at to see whether you have a fraud in the inducement claim versus a claim that would be more of a breach of contract claim, which is future performance. And again, if the panel doesn't have any other questions, we'll rest on our papers for the remainder and we'll just wait to rebut counsel's opposition.
Counsel, you discussed in your initial brief the damage argument.
Oh.
Can you hear me, counsel?
I'm having trouble hearing.
Yes.
In your initial brief, is that better?
I'm sorry, Your Honor, the audio is not coming through.
I can't hear.
Can you hear us now?
Yes, I can hear you.
Yes.
How about now?
Absolutely.
Counsel,
Better.
thank you. In your initial brief, you discussed the importance of damage, that they're not identical here. You cite Pebbles that also looks at damage. It's one of our sister courts. Under a prior analysis under the economic loss rule, we would concentrate and key focus on the nature of the damages. Under the independent tort doctrine, I understand Pebbles did it in the third DCA. The third DCA has done it, but can you tell me why you think it's appropriate that we look to damage, what it tells us about the independence of the action since they're not identical?
Yes, and yeah, in Peebles and also in the I think the Island Travel case, they both talk about how the damages have to be also distinct for to get around the independent tort doctrine. So here we have alleged completely distinct measures of damage between the breach of contract claim, which obviously would be stayed because of the bankruptcy, and the fraud and the inducement claim. And it's actually the fact that the contract does not allow for certain damages that would be attainable under the fraud claim, which is the distinguishing feature. The contract allows for certain payments that Arlington would receive. If there's a breach of the contract, that's all they can recover. And there is also a limitation on any other types of damage that are contractually permitted. But the fraud claim doesn't have those types of limitations. So the fraud claim would look for lost profits, which are not contractual, reliance damages, which would not be contractual. And also we've alleged in count 2 of the amended complaint, enterprise damages, which would be the measure of damages if the company were to simply go out of business because of the impact of the financial impact of this.
Understood, counsel. I asked a poor question. Let me ask a better question.
Okay.
Why does it matter? Under the independent tort doctrine, which is not the economic loss rule, I understand that there's 2 cases out of the third which look to damages. Our court hasn't spoken on this issue yet. Can you tell me why you think it matters that the damages are not identical in when we apply the independent tort doctrine and whatever formulation you think it has? Why do damages play a key, in your view, a key part in the analysis?
Okay. So my answer to that really is I don't think damages really play a key in it. So, and the reason I come to that conclusion is based upon, again, the Costa case, the Pruitt case, the Yukon case, which all say that the independent tort doctrine, and I'm sorry, there's also one other case that we cited, it's the airline case, I think it's UNC JR. They all say that the independent tort doctrine does not apply when you're not a signatory to the contract. So I don't think it would apply, the damage model would not apply there whatsoever. But if the court were to look at the distinguishing damages, which we would have to show if the court were to follow Peebles and follow Island Travel in that regard. All we would have to show is there is a different measure of damages, because in both of those cases, it was precisely the same measure of damages that were being awarded. I think those are both post-trial cases, and that's not the case here at all. So I don't think the independent tort doctrine in this particular case would apply at all, meaning the damage issue would be inapplicable. But if it did, we have different damages anyway, which still would exclude us from any protection or exclude them from the protections of the independent tort doctrine. And I hope that answered your question, Your Honor. And if there are no further questions from the panel, I'll rest at the moment until my rebuttal.
All right, we'll reserve the rest of the time. Counsel for
Thank
appellee, whenever you're ready.
Good afternoon. Thank you, Your Honors, for allowing us to appear by Zoom. May it please the court, Laura Wendell, Weiss Serota, on behalf of the appellee, Stephen Galvin. Your Honors, this really is a breach of contract case. In this case, U.S. Credit, the company, partially performed and then it breached. And when provisions of the contract are breached, the parameters of the claim are defined by contract law, not tort law. Now, fraudulent inducement is into a contract is an exception to that. But what is a fraudulent inducement? It's a trick or it's a bait and switch, but there's no trick and there's no switch when the alleged misrepresentation is made an express term of the contract. And that's what we have here.
Counsel, can you hear me? Excuse me, ma'am. Are the allegations contained in paragraph 33 of the amended complaint in the contract? And if so, can you tell me where in the contract the allegations contained in paragraph 33 are?
I'm just looking at paragraph 33.
Mm-hmm.
Yes, the allegations are in the representation that there would be $350 million worth of damages are in the contract, in the agreement, paragraph, page 1. USCI will provide lenders that can lend on a nationwide basis and that will commit up to $350 million annually for eligible funding of eligible loans.
Sure. I understand that the contract says that they will do those things. But as I read paragraph 33, it states, for example, that Galvin repeatedly and expressly represented that USCI had contracts in place with various lenders that allowed that company to allowed them access to funds in excess of 350 for use in Arlington's platform that would fund home improvement projects, and that those funds were readily available for disbursement. That sounds different.
Yeah,
that sounds different, right? Than I will give you funds. I promise I will give you the funds that I have. The complaint looks to me in if we just look at paragraph 33, like they're saying, I have those funds. Isn't that different?
Well, it is different. And the distinction between, I have to concede that it's different. What's alleged is a present statement that turned out not to be true. The contract was breached. What makes it a breach of contract case and distinguishable from the Pruitt case and the Yukon case is that there actually is a contract provision. The present fact, the present statement became a future promise. In the context of fraud is a present statement. It doesn't become actionable, however, when the exact same promise is made in the contract. In Pruitt,
Counsel, what case holds that?
Go ahead.
The cases that they rely on, Pruitt and Yukon, it's silent as to, in each case, the contract is silent as to what distinguishing between present and future. There's no future promise. It's not a present fact and a future fact. It's what's going on in the present, and is there a promise? And here there is a promise. In Pruitt and Eucken, there was no promise consistent with the present fact that was stated. And that's why in Pruitt and Eucken, there was a claim for fraudulent inducement. Here, there's no switch. It says it in the contract. That's our position. And is there a case that says,
The counsel,
yes,
you just agreed with Judge Brownlee that there's a difference, and that is the complaint alleges in paragraph 33 a statement of fact that is alleged. We're at the motion to dismiss stage. I'm not saying whether the plaintiff can prove these allegations, but they've alleged that there was a false statement of fact made. And then your argument is, well, it was, I don't want to misquote you, but transformed into a promise. So you agree?
yes. What was,
Counsel?
where is, oh, I'm
Counsel,
sorry.
sorry. So you agree that this statement of fact that was made during the communications alleged in paragraph 33, that did not become a representation or a warranty in the agreement? Do you agree that it is not, that statement of fact that was made before the contract did not become, here's a representation of facts in the agreement?
I do not believe it's a representation of fact. It is a promise in the agreement. It is a promise in the provision that I read to you.
And so
Actually, it cites, it's not in the recitals, it's in the responsibilities of U.S. credit. So what case says that if it appears in the contract, it's not fraudulent inducement? Hotels of Key Largo.
Well, I'm sorry,
Inspiration.
hold on. I want the case that says if a statement of fact that is false is made before the contract, and that statement of fact is then written as a promise in the agreement, that is not an independent fraudulent inducement claim.
I don't think it's a fraudulent inducement claim. It might be a fraud claim. That's the Costa case. Costa is a fraud case where the term in the agreement itself was false and could not be performed. There is no claim for fraud here. There's a claim for fraudulent inducement. In Costa, the loan couldn't be performed because the collateral for the loan had previously been sold. Representations were made to the contrary, and they were made in the agreement, and that was a fraud case, and the contract couldn't be performed. Here you have performance of a contract and a breach. You have an expectation that the funding is going to chirp along based on the promise, and it doesn't. It's a breach of contract.
It wasn't just to provide funding. With regard to the fraudulent inducement, it was, hey, we already have this on hand. So we're going to, once it goes into the formation of the contract, we've told you we have it on hand, and now we're going to promise that we're going to pay all of these things to you. That's distinguishable, I think, from what you just articulated.
But the principle of the distinction between fraudulent inducement and contract is the overarching principle is it interwoven with, is it related to, is it part of performance of the contract? And whether it was past, present, or future, it's the performance of the contract that fails. That's,
Well,
that's the reason.
they could have breached the contract in two different ways. They could have had the funds and then decided not to fulfill their obligations under the contract, or they could have never had the funds and therefore been unable to fulfill their obligation under the contract. Both would result in breaches of contract. One would be a present fact, I think, which is what counsel is arguing. One would be a present fact that is untrue, for which a cause of action may arise that predates the contract obligation. Why is that not, why is the first example not independent?
I'm sorry, why is it not independent? Because it's the exact same statement that's in the contract. And the contract can be performed without it.
Not.
I mean, in Pruitt, there was no promise that the racing team was funded. It was just an inducement. It was a bait. The performance was on the other side. The contract.
But isn't there allegation that this was a bait?
That's the point, right?
But there's no switch because it's in the contract.
Counsel, how would you distinguish this case from the holdings made by the Florida Supreme Court in HTP Limited v. Linnaeus Areas? And I'm not even going to try to pronounce that last word.
Let me just pull, I believe that in HTP, the distinctions that's made is where the alleged fraud, the alleged fraudulent inducement is interwoven with the breach of contract. I don't think there's any dispute here. There can't be a dispute that it's interwoven with the breach of contract. Now, in this case, it's exactly interwoven, and the terms of the contract say we're going to do exactly what we said we're going to do. We're going to fund these agreements.
Well, let me point you to the language quoted with approval by the Florida Supreme Court when they're quoting the Bankers Trust v. Pacific Employers Insurance Company case. It says one who has been fraudulently induced into a contract may elect to stand by that contract and sue for damages for the fraud. When this happens and the defrauding party also refuses to perform the contract as it stands, he commits a second wrong, and a separate, distinct cause of action arises from the breach of contract. The same basic transaction gives rise to distinct and independent causes of action, which may be consecutively pursued to satisfaction. I'm struggling on how I could affirm.
It goes on to say that fraud in the inducement is a special case. This is not a fraud case. No, there's no claim for fraud here. This is, had they wished to bring a claim for breach of contract and a claim for fraud, saying that they never had the $3 million and yet they promised it, that would be Costa. That would be a fraud claim. But there is not a fraud claim here. There's an attempt to bring a fraudulent inducement claim, which differs. And it differs because the fraudulent inducement case law looks to whether or not the alleged misrepresentation is interwoven with and inseparable from the contract. That's the broader general principle. I think that it is significant and important that the Pruitt case, the representation had nothing to do with performance of the contract. The representation made in Pruitt was, hey, we don't need your money. There's no provision, Pruitt says. This representation did not appear in the contract. There was no promise made in the contract that the racing team would put money in as well. It was an inducement to an investor to put money in, saying, hey, we don't even need your money. That's not what we have here. We have a breach of contract where what was promised in the contract and what was represented before the contract wasn't performed. Had they brought a fraud claim like Costa, yes, then they would have had two causes of action. The contract was fraudulent, and it's a breach of contract and it's a fraud claim, and Galvin was actively involved in the fraud. That's Costa. We don't have Costa here. I think the issue of damages comes second to the issue of whether or not there is a fraudulent inducement claim stated in the first instance. Is there a separate representation that's not interwoven with the contract? No, here there isn't. But as counsel conceded, the count for breach of contract has a different damages clause because the contract itself limits liability. So here the parties have contracted to limit liability. That takes it out of the realm of tort. That the fact that they are looking for whatever these damages are that are called, and I believe that they are contract damages, their losses as a result are it's a circumvention of the contract. The parties made an agreement as to what the liability would be.
But Galvin never signed that, right? As an individual, he's not signing that and agreeing to limit his liability for any actions taken in furtherance of negotiating that deal. Is that correct? So
well, the contract has a limitation of liability.
but he's
Hey,
not a part of the contract.
Every time let's sue the CEO for fraudulent inducement so that we are not limited by the contract. That's what's happening here. The individual CEO negotiates a contract. They talk about what the contract's going to do. They talk about what's going to happen. If every time a CEO negotiates a contract and the contract is ultimately breached, and during the negotiations, they talk about how the contract's going to work and what the term of the contract are going to be, then there'd always be a fraudulent inducement claim every time a CEO discusses what's going to be in the contract and what the terms of the contract are going to be before the contract is made.
I mean, I think that's an overstatement.
Couldn't the limitation of liability specifically refer to the party's officers, directors, employees, and agents as well?
You mean had it done that?
Right, that's something that could be negotiated by the party.
The contract, sure, that could be negotiated by the parties. But it's the contract is a contract between the entities, right? So it's a limitation of liability between the entities. if the contract were to spell out the CEOs shall never be liable for breaches of the contract. And if they are, this is their limitation of liability, then the CEOs would be parties to the contract. They're not parties to the contract. The other thing that distinguishes this case from cases finding fraudulent inducement, and certainly from Costa, is that the contract was performed. It's alleged in the complaint that the contract was performed for 6 months out of the first year contract term. So the fact that the contract also, the complaint also alleges that the CEO said, we made a mistake. We didn't perform under the contract correctly.
Thank you, counsel. If you want to finish that one thought, that your time has expired.
Okay.
All right.
So we would say this is a breach of contract case in sum, and in terms of the trial court correctly relied on cases finding that the independent tort doctrine applies, and it applies against individuals in the fraudulent inducement context. And we would respectfully request that you affirm. Thank you.
Counsel for appellant, whenever you're ready.
Thank you, Your Honor. I want to start with the policy argument made by counsel, which is if this were the law and you can sue a CEO for fraud in the inducement, then there'd always be a fraud claim that goes along with a breach of contract when there's negotiations. First of all, if there's no fraudulent statement, that would never happen. So we would hope that an officer would not make fraudulent statements. But we also cited the 5th DCA case of Billington. And I think that lawyers are smart enough to come up with provisions like the one in Billington, where if you expressly disclaim that you're relying upon anybody else's representations, then you're waiving a fraud claim, well, the contract can certainly say that. Our contract does not say that. And so the sky is not going to fall if the court continues along the line of cases like Costa that allows an active participant in a fraud to be sued for fraud in the inducement. And that goes to my next point, which is this is a fraud in the inducement case. This is not fraud in the performance. This is alleged as a fraud in the inducement claim. Paragraphs 31 through 38 of the complaint expressly state that they relied upon these representations as to the availability, the current availability of $350 million that was approved. In reliance upon that, then they signed the contract. So it is a fraudulent inducement claim. It's crystal clear in our complaint that we're not suing for fraud in the performance. And this was a bait and switch. So the bait, of course, was we have the money right now. It is present, available for you. And that turned out not to be true. So that also is why the statements in Pruitt, I think, are applicable to this case when it comes down to the bait and switch aspect of the case. And then just finally, I do want to distinguish the case of Hotels de Key Largo, which was relied upon by counsel. And the distinguishing factor in that case, which it does say that if the contractual claim is interwoven with the fraud claim, then there's no fraud claim. But in that case, they were suing the same party. It was the contracting party that was being sued for fraud. And the court found, well, it's the same term that you're suing for the breach of contract in that same complaint or in the same contract. So you can't also sue for fraud when the express provision is also available to you in a contract claim. And that kind of goes back to my original argument, which is in Costa and the 4th DCA line of cases and the Southern District of Florida as well, which say that if you have an independent tort defense, you cannot apply it to a non-signatory to a contract, which is exactly who Mr. Galvin is in this case. So in closing, Your Honor, we would respectfully request that the lower court's order be reversed and the case be remanded for further proceedings on the fraud and the inducement claim as pled. Thank you very much.
Thank you, counsel. We appreciate your argument today and your briefing in this matter. We are going to hear our third case of the day now. Thank you.
Thank you very much. May we be excused?
Absolutely. Our final case of the day, if you